The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. 2 cases will be submitted this afternoon, both oral argument. The first case is Nick C. Rhoades versus State of Iowa, and the second case is Exceptional Persons Incorporated and Others versus the Iowa Department of Human Services. We'll now hear the arguments in the Rhoades matter, and Mr. Johnston, you may proceed.
Chief Justice, may it please the court. This is an appeal from Bremer County District Court. We filed a complaint or petition for Mr. Rhoades pursuant to the unlawful imprisonment chapter of the Iowa Code, chapter 663A, after this court reversed the conviction of Mr. Rhoades and after the Blackhawk County District Attorney dismissed the case against him. The state claimed in a motion in the Bremer County District Court that Mr. Rhoades could not be a claimant under chapter 663A because he had pled guilty to the criminal charge that he was originally convicted of and that this court set aside. However, it seems to me that, and I want to submit to the court, that it's fairly easily disposed of. This court ruled that the guilty plea was invalid. The court ruled that the guilty plea was invalid because Mr. Rhoades had an ineffective assistance of counsel when he pled guilty in Blackhawk County. And secondly, that the allocution before the court when the guilty plea was offered was inadequate to state facts that constituted evidence of guilt under each element of the statute. And the particular part of the statute that related to was whether or not the defendant, Mr. Rhoades, in that case, had intentionally transmitted HIV-infected semen to the person who claimed to be the victim.
Doesn't the statute, though, require that he has to be convicted by a court or jury of the offense charged? So even if the guilty plea was invalid, he was never convicted by a jury or court of the offense charged.
Justice Wiggins, I suggest he was convicted by the court based upon the guilty plea that was tendered. The court entered a judgment of guilt, and that constitutes, to me, a conviction of guilt. Clearly, he was not convicted by a jury, but he was convicted by the court and sentenced to 25 years in prison, and he began serving that sentence. So if that's not a conviction, I don't know what is. He clearly was convicted.
I think the language is a little bit clearer than that. It says the individual did not plead guilty to the public offense charged, but was convicted by the court or by a jury. And obviously, to me, that insinuates that it was either the jury convicted him or the court in a non-jury trial convicted him. Wouldn't you think that's the more rational way to read that language? I
don't, Your Honor. I think that a conviction is a conviction, whether it follows a trial or not. The reason, as I understand it, for the provision in Chapter 663A that refers to the plea of guilty is that the legislature wanted to distinguish between a case where a defendant had actually done the act that constituted the crime, but was perhaps then found not guilty because under the exclusionary rule, some of that evidence of guilt could not be admitted. And we have in the record the affidavit of Representative Bill Bruneau, who was one of the sponsors, that supports that position.
But Doesn't the actual innocence requirement sort of take care of that issue?
He has to go back to court at some point, and I'm gonna get to that.
But my point is that doesn't the actual innocence take care of the situation where there was evidence suppressed or something like that, and therefore the conviction is set aside and the person is released from prison? I mean, here the language, as Justice Zager said, requires that the individual did not plead guilty to the public offense charged.
Mm-hmm.
And in fact, your client did plead guilty, right?
Your Honor, I think a guilty plea has a certain DNA to it. It's not just somebody coming into court and saying, Your Honor, I'm guilty. Part of the DNA of a guilty plea is there has to be an effective assistance of counsel, and the person has to admit facts on the record that constitute guilt. And Mr. Rhoades never did that. There's a word in the statute about intimate contact, and then the statute defines intimate contact. And this court ruled in Mr. Rhoades' case on appeal from the post-conviction relief action that there was no evidence of intimate contact. So my position is that there was no guilty plea because the elements of the guilty plea were not there.
There are some states that look at the statute, and it's similar language that said if the guilty plea is void rather than voidable, and I don't know what that means, but if it's void rather than voidable, then you would be able to recover in the statute. I think Ohio is one of those states that has interpreted the statute this way. But, was the guilty plea void or was it voidable? And why would it be one or the other, at least in your analysis?
Well, Justice Wiggins, there's one thing that you and I agree on, and that is I don't understand the difference between the two. I do believe that the guilty plea never existed.
For some example,
I think it was void because it never existed.
Some states say it can only be voided if there's no jurisdiction.
Mm-hmm.
I mean, when you start, and if you look at our cases, we use the word void. I've looked at all our Iowa Supreme Court cases, and we use the word void in about 10 different ways in these cases.
Excuse me. This guilty plea was void. It was void because the necessary elements for a guilty plea were never there. And Mr. Rhoades has the right now to prove his innocence. He can't just prove he was not guilty, but he does have a right to try to prove his innocence.
I mean, one could say that the conviction on the plea of guilty is no longer valid, but the statute isn't worded that way. It simply says, did he plead guilty or not? It's sort of that seems to me that just goes to what the individual did, not to what the court did. And in this case, we have a statute that just says the individual focuses on what the individual did, right?
Well, I'm not sure it quite says that, but I think that everything would hinge upon the individual knowing what he was doing. I think at the time Mr. Rhoades pled guilty, I think based upon the counseling that he had gotten from James Metcalf that this court ruled was ineffective, he thought he was guilty. And he went into court and he said, I'm guilty, because his lawyer told him to do that. But he did not understand, and the evidence record clearly shows, he did not understand the elements of the offense to which he was pleading guilty, and he was not guilty of the major part of the offense, that is that he had intimate contact, meaning the intent to transmit HIV-infected semen to this other person that he was involved in sexual contact with. So I just, to me, and I could be wrong, obviously, but there is no guilty plea. The guilty plea was void from the beginning because it did not have the necessary elements for a guilty plea.
Is there a parallel to the law of res judicata where a judgment will have preclusive effect unless and until it's reversed on appeal? Here, he's in prison because he pled guilty. Mm-hmm. Later, we vacate that guilty plea, But during the time he's in prison, he's there because of his own plea.
I don't think the statute makes that distinction. I think the only distinction the statute makes is if he is in prison because he did the act that constitutes the crime, the statute doesn't apply. And I think this court's ruling in the post-conviction relief action clearly shows that there is no evidence that he did the action for which he was convicted. I don't quite understand your question, and that's my fault, but I hope I'm responding to it, and I'm trying to.
No, I appreciate it. You're not agreeing with the res judicata analogy. I get that.
I think what's res judicata in this case, and what should be res judicata in Bremer County, is this court's opinion in Mr. Rhoades' post-conviction relief action that the guilty plea is invalid, and that he is not guilty of anything, and that he is innocent of the charge for which he spent over a year in jail and prison.
Well, again, I guess I differ in that interpretation of things, but even in the Rhoades case and the PCR case, the guilty plea was simply vacated, and then it was sent back to the district court with the idea that the state, if they wished to, could attempt to resurrect the charge, they could resurrect the plea, they could do any number of things that they wanted to, and I think that was all part of the opinion there, was that they could go down and try to establish that there was in fact a factual basis for it. So it really was just vacated with instructions, and the state, at their choice, could have. They elected not to pursue it in this case because for whatever reason it doesn't really matter. But to me, there's a big difference between vacating a conviction or a guilty plea in this case and then sending it back with instructions that you can handle it as you want to, than saying that the whole thing was void.
Except that this court did rule, and it is res judicata, that the guilty plea was invalid, that it was without effective assistance of counsel, and that it was not based upon an allocution by the defendant anywhere else or anyone else, including the county attorney, who was asked during the guilty plea if she had anything to add, and she said no. And nobody during that guilty plea made any statement of evidence that constituted the intentional, intimate contact that the statute required.
Let's take an example here. Let's say for some reason your client would plead guilty to a sexual assault charge, and 20 years later DNA exonerates your client. Would they be able to collect under the statute?
Yes, I think so. You know, I think the court needs to understand.
Pled guilty in the statute says someone who does
Well,
not
if they
plead guilty.
well, I didn't quite understand your full question.
I say they pled guilty.
If they pled guilty.
And they pled guilty for whatever reason.
No.
Bad counsel or anything, and it turns out 20 years later, because the evidence looked bad against them, it was eyewitness identification or something, and 20 years later DNA exonerates them. Are they allowed to recover under the statute?
I think it depends upon the facts. I think probably not. I think that if a court, this court or any other court, were to find the guilty plea was invalid or void, as I suggest this one is, yes, they would be able to. And I think there's good reason for that. I mean, I don't have to tell this court, you're more mindful of this than I am, about the harm that a person's life, that results to a person's life when he's convicted of a felony and is put on the sex offender registry.
Well, what's the difference in that case that Justice Wiggins just mentioned in our case?
I think there are more ambiguities in Justice Wiggins' hypothetical.
Well, not really, because the DNA comes out 20 years later. He's been in prison, and it's going to come back to the district court, who's then going to vacate the conviction, and we're going to be right back here where it sounds to me like Mr. Rhoades is. I mean, just tell me what the difference would be there.
I think you've persuaded me that I misstated my answer to Justice Wiggins. I think the cases might be the same.
Oh, maybe not. Maybe the guilty plea was valid, but the conviction is vacated.
I mean, there are just a lot of ambiguities about Justice Wiggins' question.
Well, in his hypothetical,
I mean that.
Sure.
I mean that in all
There's
respect,
ambiguities in all our
as you well
questions.
know.
You told me that before when we were practicing out there.
Yeah, I'm too old to insult this court, frankly.
I'd like to pursue a line of question I think that Justice Mansfield at least introduced, and that is this. This provision that we're looking at, dealing with guilty pleas and convictions and so forth, this exception, has to have some meaning. And the concern that I have and that I sense that he was working on is that, well, if we say all guilty pleas that are later determined to be invalid do not have any impact under the statute, where does that leave us? What life is left? The statute, unlike some other statutes, is not an actual innocence statute. I mean, there's a few out there that just say actual innocence, that's it, forget it. The legislature has put in some qualifications, so we have to give it some kind of life. And I'm interested in your response.
I see my time is up, but I will answer, of course, the question. I think if the guilty plea stated evidence that made the defendant guilty of the crime, but he was convicted for some other reason, then I think the guilty plea would prevent the application of this statute. But so long as is in this case, the guilty plea did not state evidence that indicated the defendant was guilty, then I think the guilty plea, as it is in the statute and it was intended by the legislature, does not, in fact, bar the application of the unlawful imprisonment section. Thank you, Your Honors. It's been very enjoyable. Appreciate it.
Thank you, Mr. Johnston, as well. Mr. McCormally.
Mr. Chief Justice, and may it please the court, this court should affirm the district court's dismissal of this case because the plain language of Chapter 663A bars recovery following a guilty plea. Your Honors, honestly, I don't have a tremendous amount to say in addition to that.
Well, let me ask you, is he convicted of a crime?
Well, certainly he was convicted of a crime. He was convicted of criminal transmission of HIV.
Is that conviction a valid conviction?
Well, the conviction was vacated, and to Justice Wiggins' question about the difference between vacated and void, you mentioned the Ohio cases. I think what's interesting about the Ohio cases is that there is a Court of Appeals decision in Ohio in 2006 that said a guilty plea based on ineffective assistance is void. 7 years later, the Ohio Supreme Court came out with a decision saying a guilty plea based on ineffective assistance is vacated.
Well, but it was a particular case. I mean, the Ohio case, the problem with a guilty plea in the Ohio case was that the trial court failed to inform the defendant of the array of punishment that might be available. And that was the basis for vacating that plea. That's different, it seems to me, from vacation of a plea where there is no evidence of an element of the offense. Clearly, I think clearly, in the Ohio case, the court had the power to enter a guilty plea, but frankly missed the boat in terms of describing what the range of punishment was. Here, though, the argument strikes me as somewhat different, and that is that there was no evidence, I mean not even insufficient evidence, there was no evidence of a particular element of the offense. So I'm not 100% sure the Ohio case, obviously it's not binding on us, but I'm not 100% sure the Ohio case is on point because of the nature of the flaw in the plea agreement.
Sure, and let me address two parts of that, Justice Apple. In the first place, in the guilty plea colloquy that Mr. Rhoades did in the district court, the judge went through the elements of the crime and asked him, did you engage with intimate contact with another person? And his reply was yes. Now, this court later determined that because of the technical definition of intimate contact in the statute, the court did not develop a sufficient factual basis. So I would disagree that there was no factual basis. Mr. Rhoades said yes to that question. It was insufficient, but it was
No
not.
I guess what I should have said, and I may have misspoke, but there was no factual basis for an element of the offense. I mean, that's what we said.
Well, I think this court said it was unable to take judicial notice of something that it had taken judicial notice of before.
Right, but if there was some other fact, I mean, maybe we're quibbling, and I really don't mean to quibble, so.
Isn't that why we're here, Your Honor?
You know, but it seems to me, had there been some evidence of the intimacy requirement, we wouldn't have vacated the plea. Admittedly, we said we weren't going to take judicial notice, but then we scoured the record and said there's no other evidence in the record, at least, and then remanded it back, as Justice Zager was saying. There could have been further proceedings below that could have established a factual basis, but the prosecutor, I take it in his discretion, chose not to proceed.
Yeah, and I think that the fact that it was remanded is actually the answer to the void versus vacated question. If the guilty plea had been void, if it had just been illegal, and to me that's what void means, is that this guilty plea should never have been allowed to exist under the law, that would be void. If that were the case, it wouldn't have been sent back.
Let me make this more complicated then, because the U.S. Supreme Court has sort of decided this issue in the McCormick case, McCarthy case, I'm sorry, and they say here, and I'm going to read to you, consequently, if a defendant's guilty plea is not equally voluntary and knowingly, it has been obtained in violation of due process and is therefore void. Moreover, because a guilty plea is an admission of all elements of a formal criminal charge, it cannot be truly voluntary unless the defendant possesses an understanding of the law in relation to the facts. And that's what happened in this case. We set it aside because there was no understanding of the law in relation to the facts. And the U.S. Supreme Court says under the due process clause of the United States Constitution, it's a void guilty plea. So, I'm struggling with this. I really am, because, I don't know what void means. And the real question is, even if it's void, does it make a difference under the statute?
Yeah, and I guess I'd go back to that same Moore case we were talking about in Ohio, right? In Moore, the trial counsel not only did not perform his duty, but he failed to inform his client of exculpatory evidence, right? There was gunshot residue. The gunshot residue test was exculpatory. They didn't tell him that, and he pled guilty. So in that case, to me, that's very clearly, that guilty plea was not knowingly and intelligently entered into.
Let me just make this a little more complicated. The U.S. Supreme Court remanded it back down to see if they could make a factual showing just like we did, but said it was void, not vacated, under the Constitution. So that's my problem.
So,
if you had a
well, I guess to me that, and this is where, and as Justice Mansfield pointed out in his concurrence in the Rhoades case, that this court's jurisprudence of ineffective assistance of counsel is a little bit different. At the time Mr. Rhoades entered into his guilty plea, the Keene case was the law of the state. The facts of the case were what they were. And Mr. Rhoades, again, answered yes to all those questions in district court, knowing what he knows now. His counsel advised him, based on the law, as it is on the books right now, this is where we are. And he entered his guilty plea based on a full knowledge of those facts and the current state of the law. Now,
aren't you kind of, I'm going to maybe interrupt this. I kind of agree with Justice Wiggins. Aren't you making it more complicated for yourself when you try to go down this void versus vacating and distinguishing among guilty pleas? Does the statute distinguish among different forms of guilty pleas?
It absolutely does not. The statute says if there is a guilty plea, that is a bar to recovery under 663A. I raised those issues in my brief because I thought this court needed to be aware of case law in other jurisdictions. And the one set of cases that we haven't talked about are those in New Jersey. And the New Jersey courts, and I think this is a really interesting set of circumstances as well. In New Jersey, there was a literal conspiracy by prosecutors to convict people. And those convictions were overturned on constitutional grounds. But because those individuals had pled guilty, the New Jersey court said they were barred from recovery because, and this is an element of the New Jersey statute that is not the same language but the same idea, the defendant cannot have been a participant in his own conviction. In this case, that's what our statutory provision does as well. It says if you pled guilty, if you participated in your own conviction, you cannot recover under wrongful
Is he
imprisonment.
really a participant, though, when he's given the advice he was given here? That's what bothers me. I mean, I understand what you're saying, but, you know, when you have ineffective assistant counsel who really did something they shouldn't have done, are they really participating in their own, or are they subject to the, I mean, is their only remedy left to sue their counsel for malpractice? I mean, is that what they have to do?
Well, I think that would be a better option than 663A. I think this court recently had a case about malpractice that I think might shed some light on that particular issue as well, especially as it relates to the innocence issue. But 663A is a limited waiver of sovereign immunity. In order to recover under this provision, you have to meet certain criteria. And then if you meet those criteria, then you have to show clear and convincing evidence of innocence.
Mr. McCormally, I don't think ultimately we are interpreting the statute, a statute in which the legislature has provided a remedy for wrongfully convicted persons. And we are then interpreting, is it subsection 1B or whatever it is. What purpose would the legislature have to confine this statutory relief to those persons that were convicted by a judge or a jury, as opposed to those people that were convicted by a guilty plea? Why would the legislature make that distinction?
Well, it's hard for me to get inside the head of the legislature sometime. But from my perspective, somebody who is wrongfully prosecuted, where there is some kind of prosecutorial misconduct or some sort of malfeasance that railroads a person into prison, prevents a clear avenue where somebody should be able to recover for the wrong that was done to them. When there is a guilty plea and somebody has said, yes, I did it, and admits to the elements, as Mr. Rhoades did in his colloquy, to me that prevents a different circumstance. There was no malfeasance here. There was no misconduct here. There was an insufficient record made, and there was insufficient advice given to Mr. Rhoades. That's not the kind of malfeasance that I think speaks to the intent of this statutory provision.
And the legislature could define the group of people that would qualify under the statute in pretty much any way they wanted, couldn't they?
Absolutely, and I think it's instructive that rather than requiring a showing of actual innocence, they want a clear and convincing showing of innocence. To me, that's makes it easier in some circumstances for somebody to be able to recover. And so I think that the legislature, defining it in the way they have, has set out a clear group of people that they believe this recovery should be available to, and Mr. Rhoades, by virtue of his guilty plea, is not among them. And I think you're absolutely right. I have made this more complicated than it needs to be. Vacated versus void is, it's one of those nuances that they talk about in law school and then everybody promptly moves on from. But in this circumstance, where the clear distinction to me is this case was sent back for further proceedings. What happens in further proceedings?
Well, no, because, I mean, yeah, it was sent back further proceedings because in part the state, you know, the guilty plea, arguably, the guilty plea arguably was null and issue. That doesn't mean there's a dismissal of charges. That just means the guilty plea is off the table and you go back to square one. And then the prosecutor, in his discretion, can step back and decide, well, what do I want to do now? Do I want to make another attempt at a plea? Or do I want to go on to trial? Or do I want to dismiss it? But the prior guilty plea is as if it never happened, wiped off the face of the earth, forget about it. I mean, so the remand doesn't necessarily doesn't necessarily dictate whether the plea bargain was void or voidable, it seems to me. The mere fact that there was a remand.
Well, I think it does in the sense that if it was truly illegal, if it was void in the sense of just not allowable, then it would have been remanded with further instructions for dismissal, quite frankly. The Ohio court has language in that Dunbar case that says just because a guilty plea was vacated doesn't mean it never existed.
Well, and that may be right. And in fact, I'm almost inclined, I mean, I see that, and I think that some guilty pleas are voidable and not void. Indeed, the one where the trial court misstates what the range of sanction is, that strikes me on the surface as being voidable. It's not that the court lacks the power to convict somebody based on a guilty plea. It's that there was an error in the procedure. But arguably, it's different when you say there's no evidence of a particular element.
The one circumstance where I would agree that a guilty plea is void is when the statute itself is unconstitutional or otherwise illegal. In that circumstance, absolutely, the guilty plea is void because it was against the law. This guilty plea was not illegal. It was insufficient.
The state does not have the power to put someone in jail under the United States Constitution unless there is a factual basis relative to the law and facts. And that's what the U.S. Supreme Court says. So how is it any different if a statute's unconstitutional, if the procedure's not unconstitutional?
Well, I would say that, the McCarthy case says the guilty plea has to be knowingly, intelligently, and voluntarily entered into. I would suggest to you that that happened at the time it was entered into. Subsequent developments might change that analysis, but at the time it was entered, it was voluntary. And so I would ask this court to affirm the district court's dismissal of this case.
Counsel, before you sit down, this kind of follows up a little bit on some of the other questions, but it strikes me that 663A was conceived to provide a remedy to those who are grievously imprisoned, wrongfully, okay? And so I'm not clear I understand exactly why you think someone who is convicted by a court or a jury and sent wrongfully to prison is more grievously injured than someone who improvidently enters a guilty plea and is wrongfully sent to prison, or sent to prison without a legal basis. In each instance, the state is sending that person to prison. The court is entering a conviction, and they go off to prison. Why does the guilty plea make? Why do you think the legislature would have intended that the guilty plea makes such a difference?
Well, I was about to say that it's not me who thinks it makes a difference. It's the legislature who thinks it makes a difference. The legislature included that in there. But to me, the language of the New Jersey statute answers that question, which is...
Oh, but the New Jersey statute talks about by his own conduct caused or brought about his conviction, I think.
Right, and that's exactly what it says.
That's a lot broader than the guilty plea. I mean, one could easily argue that the guilty plea has to be a valid guilty plea, whereas the conduct language in the New Jersey statute arguably is quite broader. If by your own conduct, meaning you plead guilty or you confess even falsely to a crime, by your own conduct, you're part of the causation that leads to the conviction.
Sure, and my time has expired, but I'd like to address this. So to me, the by your own conduct expands it in this way. It expands it to offered pleas, right? So what I think is interesting is that the guilty plea is a preclusive bar to recovery, but an offered plea isn't, right? If you just plead no contest, I don't think
in New Jersey, but what about in Iowa? What would an offered plea do?
Well, and that's what I'm saying, is I think in New Jersey, an offered plea would be barred, right? That's your own conduct. But in Iowa, I'm not sure that it would be. The statutory language says guilty plea. It doesn't say offered plea. So I think...
Offered plea is a guilty plea. You can argue the cases you want, but I think you run into a lot of treacherous waters the more you try and slice and dice among guilty pleas, as opposed to just saying a guilty plea is final.
Well, and I guess that is where I started, but given the way the jurisprudence in other states shakes out, I thought it was my duty to inform the court thusly.
You had me at plain language.
Thank you, Your Honors.
Thank you, counsel. Rebuttal?
Please, the court. May I just say that since returning from New York, I've been here twice, and it is a bit off-putting to be confronted with a court who knows more about my case than I have. But that's my feeling just now. Okay.
Sorry, let me ask this question. Why do you seek recovery under this statute rather than suing the attorney?
We know that the defendant under this statute is not judgment-proof. We don't know that the counsel has any money or has any insurance. And so this statute, I think, may very well be Mr. Rhoades' only hope for getting any remedy at all for the year he spent in jail and prison.
I say that because when you look at the statutes as a whole, if a guilty plea is a guilty plea, and we take the state's position here, your client is not without a remedy, because if you look at 815 10.6, it's appointed counsel. There's a remedy if there was ineffective assistance of counsel, and the damages are a lot more. I'm sure that if you're a paid counsel like this one was, if I recall right,
That's correct.
the remedy would be there, because you really have to waive sovereign immunity if it's appointed counsel, because you have some sovereign immunity problems. That's what 815.10 does. You got 2-year statute, so you're in the statute. You got different damages, probably more. And it seems incongruous to me that if the statute doesn't afford you a remedy, I don't know if it does or doesn't, because I haven't made up my mind yet, but if this doesn't afford you a remedy, why aren't you seeking all remedies? And I guess maybe you're afraid of if there's a pot of gold at the end, like all plaintiffs' lawyers are, but...
That's right. And I guess I can tell the court, we do have a malpractice suit filed against Mr. Metcalf. Mark Harmon and I, is that his name, Mark Harmon? Huh? Mark what? Mark Harding and I filed that suit, but I just don't think there may not be anything there. And Mr. Rhoades desperately needs some resources to get his life back on track and put together. I mean, every time he applies for a job, this comes up. And and one of the things that Mr. McCormally said is there's no malfeasance in this case. Well, in all due respect, it seems to me that a trial judge who accepts a guilty plea without making sure that the person pleading guilty understands what he's doing and understands, in this case, the statutory meaning of the word intimate contact, and that a county attorney and the police department and a defense attorney will all participate in that case without finding out or knowing whether or not the client and defendant was in fact guilty of intimate contact, which I think this court pretty much finds that he wasn't. That's malfeasance. I was county attorney for 8 years. And one of the things that you always worry about is convicting somebody who's innocent. And that's what happened in this case. And I think, what Mr. McCormally has raised in his brief, the suggestion that the defendant can't prove himself innocent. And so I guess I feel maybe I have some liberty to address that. I think the record of this court, plus the dismissal below, pretty much meets all of the criteria of section 663A for the claimant to be found innocent. There is obviously, time goes on, lives go on, there is some urgency on our part to having this matter resolved in Mr. Rhoades' favor. So if the court could look at the record and take Mr. McCormally's suggestion that it can adjudicate the question of innocence and do that now so we could take this case immediately to the appeals court and prove up our damages, in my judgment, that would be a just thing to do. Any more questions? Thanks so much. Really appreciate it.
Thank you as well, Mr. Johnston. The case is then now submitted to the court, and we'll now hear the arguments in exceptional persons.